All right, I have 8:59. Let's take a walk on the wild side and start a minute early here. All right, good morning. Welcome to our session of oral argument with the 5th DCA under our new environment. We appreciate everybody's cooperation with us under these circumstances here. Our names are listed. I'm Judge Lambert. I'm presiding today. You see Judge Edwards and Judge Cohen are also panel members. We have one case starting at 9 o'clock. We appreciate the cooperation of the attorneys to move this up from previously scheduled so that to accommodate the court. You'll see there is a clock. I don't know where it is on your panel, but appellant, each side will have 20 minutes on their appeal. Appellant, we'll assume that you want 5 minutes rebuttal time. Unless you tell me otherwise, I'll let you know when you get to the 5-minute time. The first case we have today is case 5D19-1387, NANLANN Inc. versus, well, there's a numerous appellees, but the specific appellees affected here today are Robert Pola, Jennifer Baker Pola, JENEMI Associates Inc. So counsel, if you are ready, you may proceed whenever you're comfortable. Go ahead.
Thank you very much, Your Honor. My name is Clay Resch with Sheffield Lohman Wilson on behalf of the appellant NANLANN Inc., who was the plaintiff below, and I will reserve 5 minutes of my time for rebuttal.
Very good.
This is an appeal arising out of a partial final judgment that was entered in favor of the defendants below, Mr. Pola, Ms. Baker, and a company, Gemini Associates. We're here today because the trial court resolved a disputed issue of fact when it determined that NANLANN lacked standing and that any claims against these appellees had to be brought by a company called KILGORE Properties, LLC.
Wasn't KILGORE the purchaser of the property involved?
No, Your Honor. KILGORE took ultimate title to the property as a result of the transaction, but KILGORE was not the purchaser. It wasn't even a functioning viable entity until the day the property closed.
Was there a contract for purchase and sale?
There is a contract for purchase and sale, Your Honor.
Who's named as the purchaser?
KILGORE Properties is the name of the purchaser. However, that contract for purchase and sale was signed before KILGORE by Ms. Jenny Baker, who was purportedly the manager of KILGORE Properties. At the time it was signed, though, she was not the actual manager. She did not become the manager until KILGORE's amended operating agreement became effective. That operating agreement is dated June 15th, 2007. The agreement for purchase and sale, if I recall correctly, was signed in early May of 2007. So KILGORE Properties was one of the instrumentalities that Mr. Pola, Ms. Baker, and Gemini Associates used as part of this transaction, but it was not an active participant in the transaction. It wasn't involved in the negotiations of the terms of the deal. It wasn't the purchaser. It didn't ever have possession of the funds. It didn't have a bank account. And
the actual possession of the funds is an argument that I am struggling with a little bit, because just to give you, an example, when I took out a mortgage on my house, they actually didn't send me the proceeds. The bank that I borrowed the money from sent the proceeds to the seller of the property. That didn't mean that I wasn't the one that borrowed it.
well, I understand that distinction, but again, that comes back to KILGORE not being a viable entity at the time those funds were released. And these claims that we're asserting, the claims for fraud, they're personal to the party that was defrauded, which again was not KILGORE Properties. It was our client NANLANN and its owner, Mr.
Well, that's conclusory of you to suggest that, though, is it not?
I don't believe so, Your Honor. I believe that the correspondence that between Mr. Pola and Mr. KINCHLA that was exchanged prior to the transaction shows that very clearly. The way the transaction was set up, Mr. Pola referred to his investor putting in $1.8 million, not KILGORE Properties, LLC. The first time KILGORE Properties is mentioned is in a May 3rd, 2007 email. By the time that email goes through, the material terms of the deal have already been set. The use of KILGORE Properties was simply to take title to the property at the conclusion of the transaction. And if you want to look further, Your Honor, there is deposition testimony as well, which would indicate that the funds were placed with Kilgore on behalf of and for the benefit of NANLANN.
Now, didn't Kilgore develop the property and build condominiums?
Kilgore did develop a portion of the property.
And then they sold the remaining portion of the property, correct?
The remaining portion of the property was foreclosed on. That was the subject of another lawsuit that was ultimately consolidated on this.
That's bad.
Is he not, are you out, Mr. Resch? Can you not hear us?
He's frozen in time.
Frozen.
Okay, so the clock's frozen too. Mr. Stovall,
Well, that-
you frozen?
yeah. Good.
Mr. Sobash is here.
Yeah. Oh, there we go. Okay.
Back on with us, Mr. Resch?
I'm sorry, Your Honors, did I freeze? I apologize.
Yeah, you froze.
You-
But the clock froze too, so you didn't lose any time while you were in suspended animation.
I'm so sorry.
No, you looked good.
That was a good post.
Thank you. What was the last thing that you heard, if you don't mind me asking?
And good morning. My name is Clay Roche.
We're
The
talking about the foreclosure suit was consolidated into this case, and
Okay. Yes. So Kilgore did develop a portion of the property into townhomes. Those townhomes were sold. The remaining parcel was vacant in 2013. NANLANN and the other member of Kilgore, Mark 48, ended up in a deadlock as to what to do with that vacant parcel.
Right, and that's what led to the litigation. But effectively, Kilgore did what it was designed to do, which was to develop the property. Now, the ultimate disposition of that became subject to a lawsuit, but they did what they were supposed to do. Right?
Kilgore did ultimately, yes, develop a portion of the property, although I'd say that what Kilgore was supposed to do, the reason it was used was to help Mr. Pola siphon $200,000 out of this transaction. So, I mean, you could say, I suppose, that there are dual purposes for Kilgore. Once the transaction closed, sure, the property was developed, but that could have been any limited liability company. It didn't necessarily have to be Kilgore.
Well, but it was, and they were on the contract for sale.
Yes, Kilgore was on the contract for sale, but with
Now your client didn't even get an appraisal on this property, correct?
No, my client relied on Mr. Pola to set up and make sure that this transaction that was
Well, your client didn't have to do that. Your client could have gotten an appraisal on the property, and what record evidence is there that the property wasn't worth the 2.1, I think it was at the time of the sale?
Well, I think the best evidence of that is the correspondence again between Mr. Kinchla and Mr. Pola, in which Mr. Kinchla, who's the owner of the property through Newton Corner LLC, is shown to be willing to take $1.7 million for it. If the property is worth 2.15, there's no reason to take that kind of discount.
Well, there was evidence in the record that he had a mortgage and a lien of some type, so he may have needed the money more quickly and thus been willing to give a discount. Is that right?
There is that evidence, but Your Honor, if that were the case and he were willing to take that kind of discount, certainly there would have been some effort, I would think, to negotiate or market the property, the way it was. Now,
to date, you have not established any value for the property other than what the purchase price of the contract was. And looking at those emails, neither one of which may be accurate. Is that right?
Your Honor, I believe that the owner of the property would have a good understanding, a good feel for what the property was worth. There is no appraisal in the record. I do believe that there are emails back and forth between Mr. Kinchla and Mr. Pola after the transaction occurred that show pro formas with the property being valued at that same $1.7 million level. But in terms of the actual value of the property, as far as my client was concerned, Mr. Pola was acting, not just as his agent, but as his confidant. He was his accountant, a chartered accountant in the United Kingdom. He was relying on Mr. Pola to establish and set up this deal so that it was done in accordance with U.S. law and that all the formalities were seen. my client's a UK citizen. He's not familiar with how property transactions over here work. Mr. Pola is also a UK citizen, but he had a foot on this side of the Atlantic through Gemini Associates and his daughter. And so my client was relying on him, as a fiduciary to present him with a deal that wasn't going to result in Mr. Pola being able to siphon $200,000 out of it.
So if Kilgore Inc. was actually incorporated February 1 instead of whatever the date you were referring to, and signed the contract, and there was the fraud that you say there is, would you lose then because there was, in fact, Kilgore Inc. was a viable entity before the contract was signed and then got defrauded by whatever nefarious things you believe occurred according to the record?
No, I don't believe so, Your Honor, because Kilgore Inc. was still being controlled by Mr. Pola, Ms. Baker, and Gemini Associates. So the original members of Kilgore, and it was an LLC, the original members were two companies, one called Swanlia Inc., which is not a party to this lawsuit, the other, Gemini Associates. And if you look at who set it up, it was Mr. Pola. He testified that Kilgore was just a company that was sitting on his shelf. It was formed for another purpose. It never got used. And so it just kind of shuffled off. And that's why it ended up being substituted into this transaction for the new LLC that was referenced in the emails.
Well, the other purpose was for development of property, and then that just didn't materialize, and so this transaction occurs, which is also development of property. So it seems its function in terms of development of property was consistent throughout.
I'd agree that it was set up, I believe the testimony was, for another project that just never got off the ground. And yes, Kilgore did ultimately develop a portion of this property, but it was not Kilgore that set up this transaction. It wasn't Kilgore that was negotiating it. It was, you do not see emails from Jenny Baker, Kilgore's manager, talking about the terms of this transaction. It's between Mr. Pola and Mr. KINCHLA.
People have to do things in a transaction. Companies cannot do anything other than through people, can they?
That's correct, but Mr. Pola was not the manager of Kilgore. In fact, he set it up, but it was, again, just a company that was sitting on its shelf. It wasn't Kilgore that was actually transacting the business. These people weren't, Mr. Pola, Ms. Baker, they weren't acting on behalf of Kilgore at the time. They were acting in their own interest.
But the fact that Kilgore did the transaction, that's not really anything you're that concerned about, other than trying to say because they didn't get the money from the Swiss company that somehow they didn't buy it. I mean, other than that, in terms of Kilgore being there, that doesn't really seem to be the problem. The problem seems to be you think that your client was misled as to its values and the $200,000 management fee, however you want to characterize it. Is that right?
That's correct, Your Honor. It could have been any LLC that ended up taking title to the property. The fact that the price of the property that was owned by Mr. KINCHLA through Newton Corner was inflated so that I believe Mr. Pola could siphon out the $200,000 out of the transaction. That is the underlying issue with this transaction. That's where the fraud occurred. It's not with Kilgore taking title, to the property, which it did.
And that doesn't occur if your client does due diligence and gets an appraisal, does it?
Well, I don't know about that hypothetical. Again, my client was relying on Mr. Pola, who was acting, as a fiduciary representative. They'd had a long relationship in the UK, and he was trusting and relying on him. So Mr. Pola is, in effect, acting as, the agent for Mr. McKelvey for NANLANN. In fact, if you look at some of the correspondence, in one in particular in June, Mr. Pola writes to an attorney, Joy Everett, who was the closing agent. She represented Mark 48, Mr. KINCHLA, Newton Corner, and he writes, I am the representative of the NANLANN group. We have arranged to wire $1.8 million to your account for purchase of this property. That money will be held in escrow and will be released at the specific instruction of my daughter, Jennifer Baker, who is the vice president of NANLANN and who will be the manager of Kilgore. I believe that email was in June. I believe it was June 11th or so. And I can get the exact date for you if you like. But I believe that shows that Mr. Pola is acting for the NANLANN group. He's not acting for Kilgore.
So you're concerned because the seller fraudulently inflated the sale price and that your client has now suffered damages by that?
Not the seller. Mr. Pola fraudulently inflated the sale price with the cooperation of Mr. Kinchla, the seller. Mr. Pola was acting as representative for NANLANN. He knew that the property would be sold and that Mr. Kinchla would accept $1.7 million for it. He came up with a scheme to inflate the price of that property to $2.15 million so that he could take $200,000 out of the transaction for himself. Mr. Kinchla, in exchange, keeps a 35% interest in the property, and he gets the net sale proceeds to extinguish his other debts. That is the issue here, Your Honor. Not that the seller set a price that was too high. The seller was willing to take a lower price. The seller was willing to take $1.7 million for it. And rather than come to NANLANN and say, I've got an investment opportunity, we can get this property for $1.7 million, Mr. Pola presents it as it's going to be purchased for $2.15 million. That's where the fraud occurred, Your Honors. So, we also, and I'm happy to continue on this, the deposition testimony that I referenced previously, I think is fairly clear that the money was placed on behalf of or for the benefit of NANLANN. In fact, there is deposition testimony from Mr. Pola. It's in the record at 2535. This deposition was taken in February of 2015. This was before we had uncovered this fraud. And under questioning from Mark 48's counsel, Mr. Pola admitted that these funds were sent on behalf of NANLANN. If I may, Your Honors, this again, the context of these questions is, what Mark 48 knew about the transaction and about the loan. And the question from Mr. Sadem, Mark 48's counsel, is, was there a meeting where you told Mark, was it at that meeting you told Mark about the note, the NANLANN note? Mr. Pola answers, I don't know, I can't remember. I would have thought he would have known that from the outset. The question, and how would he have known that from the outset? Answer from Mr. Pola, because where did the $1.8 million come from? Question from Mark 48's counsel, it came from NANLANN Inc. Answer, yes, of which $650,000 was a contribution, $1.15 million was a loan. So in addition to the correspondence, you have the testimony from both Mr. McKelvey and Mr. NANLANN, or I'm sorry, Mr. Pola, that money was.
Isn't the issue here whether the claim fraud has to be brought as a derivative action?
That's certainly an argument that the appellees have made, but this is not a derivative claim. Kilgore didn't suffer any harm as part of this transaction. The harm and the fraud was directed at NANLANN, and the claim for fraud is personal to the one defrauded, and that is NANLANN. It is not Kilgore. Kilgore received title to this property without having to pay a cent for it. And so I believe it'd be hard to say that Kilgore was the defrauded property in this transaction.
Why is the delay in the entry of the summary judgment reversible error in your mind?
Because, Your Honor, it created such a significant risk that the trial court would not recall and appreciate the deposition testimony, affidavits, and documents that were presented during.
That's all record stuff. I mean, the judge can go back 6 months, a year after the hearing, and go back and read it all. And summary judgment is based upon the conclusiveness of the record in favor of the moving party. So it's not like I don't remember trial testimony, which becomes problematic in delays. I mean, here the judge can go back and read stuff just like we can go read stuff, So if we run an opinion 9 months from now, we'd say, oh my goodness, we got to set it aside because we can't go back and reread everything.
No, Your Honor, that's not what I'm saying. And I do agree that the trial court could have gone back and read everything. I don't know what process the trial court had for entering its judgment, but I think in this case, that risk of a failure of recollection or just an inability to recall specifically the evidence that was presented, I think that risk was realized when the trial court resolved a disputed issue of fact.
I don't know that risk is evidenced by the fact that the trial judge ruled against you. If the trial judge resolves disputed issues of fact, you take an appeal just like everybody else takes an appeal. But in order to prevail on delay, you've got to show something that's inconsistent with the testimony, or you've got to make more of a showing than, well, there's a risk that the trial judge might get it wrong. And, when you handled a lot of dissolution cases as a trial court judge and you're doing one after the other, a week might be a delay that would risk, mixing facts up. But that, you know, you've got a certain burden to prove. You think you've met that burden, and how?
I do, Your Honor, because the trial court's judgment found that Kilgore Properties LLC paid the purchase price for the property, and that is simply not supported by any evidence in this record. Again, Kilgore.
And your position is that they didn't pay for it because the money from the Swiss bank didn't go into their account, it went directly to the seller? Is that your?
Not just that it didn't go into the account, Your Honor. Kilgore didn't have an account. It didn't have a manager. It wasn't a functioning entity. Its amended operating agreement, which made NANLANN and Mark 48 Inc. members, wasn't signed until the same day as the closing. The manager, Jennifer Baker, she was not appointed as manager of Kilgore until the same day as the closing. Kilgore had nothing to do with this transaction other than being a receptacle for the property to take title to it once the transaction closed. That was the extent of its involvement. And so,
Mr. Resch, you're down to about 120 in rebuttal. I'll give you a little bit more time. So
I'm sorry, I'm into my rebuttal time, Your Honor.
yeah, you're well into it, and
I'll
I'll give you a little more time. I should have brought it to your attention earlier.
I will reserve it this time, Your Honor.
Okay, that's fine. All right, thank you. All right, Mr. Stovash, your turn.
Good morning, Judge Lambert, Judge Cohen, and Judge Edwards. I'm Bob Stovash of Stovash Case and Tingley, and I have the privilege of representing Mr. Pola, Ms. Baker Pola, and JENEMI Associates. There was no disputed issue of fact, but it doesn't really matter. The issue on appeal is who had standing. Who had standing? And I think my colleague's oral argument today, where he spent less than 60 seconds on the issue of standing, shows that he doesn't have, or that the appellant doesn't have, a viable argument to show a direct harm. So what happened before the lower court? The lower court was faced with an argument by NANLANN that even though Kilgore Properties was a legally constituted corporation, that Kilgore Properties was formed before the contract for purchase and sale. Not that that would even matter, because as this court knows, incorporators can sign contracts for purchase and sale. But it is significant that Kilgore was in existence. That 3, a month before the closing, the contract was signed by Kilgore Properties. That 4, Kilgore Properties in fact received a loan, the loan in writing from Swiss Global. That is, Kilgore Properties is listed as the borrower. That there was a closing, and the parties, meaning the seller, Newton Corners, and the buyer, Kilgore Properties, appointed a closing agent, Joy Ewarts, an attorney in Orlando. And she was responsible for collecting all of the materials, just like any other real estate transaction, you know, doing the deed, making sure that a closing statement was done, making sure that the payment by the purchaser was placed in her trust account. And then she distributed it, not unlike any other common closing.
Well, but there were things that were unlike other common closing in this case. You had a series of emails that ultimately get disclosed that don't really look very good. I mean, it looks like these people were, you know, coming up with a plan to inflate the value of the property in self-dealing.
Well, first, thank you, Your Honor. First, I don't believe those emails show a problem in this respect. Kilgore, as we know from the record, was a single purpose entity. That is, you know, developers put property in a single purpose entity all the time. Yes, there was testimony that Kilgore Properties was an off-the-shelf company. They needed a vessel to purchase the property, and Kilgore was the purchaser. To state in this court that Kilgore wasn't the purchaser and never paid anything is just not accurate. Kilgore had to get a loan to purchase the property, and it did. Now, there was a introductory fee. Okay. There was an introductory fee. There is no evidence in the record that there was an issue about the value of the property. In fact, Mr. McKelvey testified that he thought the property was worth what Kilgore paid for it. But the real issue becomes...
You also had the correspondence where the seller indicated he would take 1.7.
That is true. But what this court does not know, because the record was not presented in this fashion by NANLANN, is that there was a lot of consideration associated with this transaction. There were, of course, as the record does reflect, negotiations as to what percentage would be owned by each member, how much money would be determined to be the membership interest amount. So, you know, we can speculate why the purchase price went up, but there's nothing that says that it is an inflated price. It's just that the price went up, but we don't know because NANLANN didn't present evidence as to why the seller moved the price up. There is no such evidence in the record that I am aware of. But the issue really comes down to, because, see, the trial judge didn't get into, you know, whether there was a question of fact necessarily about, you know, did somebody commit a fraud? What the court was trying to determine is who owned the causes of action, the standing. So if Kilgore is the purchaser of the property, then any inflated price that is allegedly paid was paid by the purchaser of the property. And so the purchaser of the property would have the claim for the inflated price. And then the indirect harm is to the two members. It appears to me that that is an indisputable fact, if you will.
So you're suggesting the claim has to be a derivative action.
It must be, and that's exactly what is on appeal. The trial court did not address the significant statute of limitations problem, did not address whether the elements of fraud had been established. What the court was addressing very succinctly was, you know, who can bring the claim? And when someone, in this case NANLANN, or McKelvey, by the way, alleges that, hey, you know, the purchase price was too high, what the court needs to do is determine who was the purchaser, because that takes us through the rest of the case. The purchaser was Kilgore Properties. To simply say to this court, well, I know that Kilgore Properties signed the purchase agreement. I know that Kilgore Properties owns the deed, owns the property, that is, the deeds in their name. But forget about that. They really weren't the purchaser. It's just not accurate. I mean, NANLANN did not purchase the property. You know, there's a case that was cited by opposing counsel, the Weiss case in the 4th DCA, where an individual purchased a boat, and then the seller in Weiss was to then make repairs. And in the meantime, the purchaser transferred the property to a single purpose entity, a corporation. So the question in that case was, you know, was it a derivative action or was it a direct action? Because there was a transfer of the property from the original purchaser to a subsequent entity. Here, NANLANN never purchased the property. I mean, clearly there's no evidence of that. NANLANN did not purchase the property. And what the court below was looking at was,
who paid for the property?
excuse me.
Whose money was it that paid for the property?
That is clear in the record. Kilgore Properties received a loan from Swiss Global to pay the purchase price. And so if you will, the lender then caused the money to be transferred to the closing agent. And there's no dispute that Joy E. Works was a closing agent acting on behalf of everybody in connection with the closing. So she received the money. She dispersed the money in accordance with the parties' directions. I think the fact that there was a loan, and of course the fact that there is only one deed, and it's to Kilgore Properties, solidified the trial court's belief that this can only be a derivatives action. And I would say this: the silence of the appellant on the issue of whether or not it's a direct action or a derivative action in their briefs and in oral argument, I think assists us in understanding that that is a big, big problem for them. We can yell and scream about that there was a fraud, which we dispute. But the issue, the legal issue for this court to determine is who can bring it. And Judge O'Kane properly granted summary judgment, finding that NANLANN had no standing. If I can turn to, and I obviously come back to this argument if need be, but if I can turn to the delay, well, clearly there's no question that there was a delay. But I think that the questions to opposing counsel really show what this is all about. This was a summary judgment hearing. It was a question of law that needed to be decided, not unlike what this court's going to do, which is a de novo review as to whether or not summary judgment was appropriate. And there was substantial discovery in the case and a substantial record for Judge O'Kane, the lower court judge, to review. But more importantly than that, although there was a delay, what is very interesting is the court made its ruling and then asked, as this court knows, counsel for both parties to draft the proposed judgment. And the parties did so and submitted it to the court. There was a disagreement about the verbiage, I believe, of one paragraph. It could have been two. But there was no dispute that the court had determined that NANLANN lacked standing. This wasn't a concern with a whole host of facts, and it was a bench trial without a transcript. That wasn't the case at all. It was the parties themselves that drafted the proposed order. Again, certainly the court, for reasons that nobody knows, of course, Judge O'Kane wasn't deposed, but the court had a delay. But the case law is very clear. It's not just delay. Something must be, quote, seriously amiss, unquote. There has to be, record evidence of some confusion. That is, the court at the trial heard, X evidence and then misconstrued it 20 months later when the final judgment was done. There is no such evidence. This idea that, there was a risk, that is not the standard. The standard is there must be something that is seriously amiss. And we can all perhaps agree that it took a while and a long time to get our judgment.
Mr. Stovash.
Yes.
I don't think that seriously, is part of the standard, but we understand what the standard is, and let's go ahead and move on. Unless you're concluded with that, I think we understand the issue of the delay.
Thank you, Your Honor. The only other comment I would make would go back to the standing argument. Just because the attorneys in the lawsuit argue that Kilgore Properties is not the purchaser. Doesn't make it so. What has to occur is there has to be a point to record evidence to support that position. And every piece of record evidence, documentary evidence more specifically, conclusively showed that Kilgore Properties was and became the owner of the property, and as a result, respectfully, the owner of whatever claim wanted to be alleged. In this case, it was fraud and conspiracy and vicarious liability. If there are no questions, I would respectfully request that this court affirm the lower court's decision. Thank you.
Okay, thank you, Mr. Stovash. All right, Mr. Resch, it says 1:08 on the clock. I'll give you 3 minutes. How about that?
Thank you, Your Honor, and I will hit these points very briefly. Your Honors, we don't need to speculate on why the price went up. There is record evidence of that. A May 6, 2008 email from Mr. Pola to Mr. Kinchla. It's in the record at 8161. Mr. Pola states to Mr. Kinchla, you owned the lot and wanted $1.8 million for it. I got a buyer in at a higher price at 2.15. That's why the price went up. It wasn't because of any decision by Mr. Kinchla to list or sell the property for $2.15 million. Now, we also heard that Mr. McKelvey may have thought that the property was worth what was.
Let's focus on the standing issue, because that's really what we need to talk about, isn't it?
Yes, Your Honor. The standing issue is, in our view, fairly simple. The party that was defrauded, the party that was the target, the mark, if you want to be uncharitable of the fraud, that was NANLANN and Mr. McKelvey. It was not Kilgore. There's no correspondence. There's nothing that shows that Kilgore is going to be, relying upon Mr. McKelvey's representations as to the value of the property. And that's what Mr. McKelvey did. He thought it was worth 2.15. That was based on Mr. Pola's statements to him. So the issue here, and this again is from the cases cited, the Weiss and Kumar cases in our brief, that the standing issue, the ability to bring a claim for fraud is personal to the one defrauded. Kilgore Properties was not defrauded. They were not the target of this scheme. Mr. Pola did not go to the owners of Kilgore Properties and say, hey, I've got a great deal for you on a piece of property down in South Orlando. He came to Mr. McKelvey, who through NANLANN was the defrauded party. That is why NANLANN has standing. That is why this is a direct action. Kilgore suffered no injury as a result of Mr. Pola's actions. It was Mr. McKelvey and NANLANN who did. So,
Mr. Rush, is there anything that prohibits NANLANN from bringing a derivative action? Unless, of course, the statute of limitations, but we're not addressing that today.
yes, Your Honor, the harm is direct to NANLANN. The harm is not anything that was suffered by Kilgore. Don't believe that a derivative action.
Well, my question is whether NANLANN could bring a derivative action.
No, Your Honor, I don't believe so, because again, the damage, the injury, the cause of action, it belongs to NANLANN as the defrauded party, not Kilgore. I believe that the direct action is the appropriate way for NANLANN to bring this claim, not as a derivative action on behalf of Kilgore, not in any other capacity other than as the party that was subject to the misrepresentations that were made by Mr. Pola, the party that came in, arranged the financing on its benefit and for its behalf. Mr. Pola acknowledges it was NANLANN who did that. This is NANLANN's claim, not Kilgore's claim.
All right.
Thank you, Your Honors. If there are any other questions, I'll be happy to address them. If not, we'd ask that the court reverse the trial court's judgment and remand this matter for further proceedings.
Okay, thank you, gentlemen. Appreciate your arguments this morning. So we'll stand adjourned for now. And we'll sign off.
Thank you.
Thank you very much.
Thank you.